Mr. Chairman, members of the hearing committee, in March of 2006, Michael Nifong was the appointed district attorney of Durham. He was engaged in a...
Let me stop you right there.
Yes, sir.
You may need to speak up a little bit, if you can.
He was engaged in a contentious political campaign to keep his office. On Friday, March the 24th, Mr. Nifong learned for the first time that an African-American exotic dancer had alleged that she was raped by 3 white men at 610 North Buchanan Boulevard in Durham. That is a house that is rented by 3 team captains of the Duke lacrosse team. By the time Mr. Nifong learned about this allegation, the Durham Police Department, working with Mr. Nifong's office, had obtained non-testimonial identification orders from the court requiring that all 46 Caucasian members of the Duke lacrosse team provide DNA samples and be photographed for identification purposes. When Mr. Nifong saw that this case existed, he immediately recognized that this case would likely garner significant media attention and decided to handle it himself, instead of having the case handled by the assistant in his office who would ordinarily handle such cases. Mr. Nifong called the Durham Police Department, notified the Durham Police Department he would be handling the case himself, and instructed the Durham Police Department to go through him for any directions on the factual investigation of the case. Mr. Nifong also made an appointment to meet with Investigator Himan and Sergeant Gottlieb of the Durham Police Department on the following Monday. So he learned about this on Friday the 24th and had a meeting the following Monday with the police department. At that meeting, he was briefed by Investigator Himan and Sergeant Gottlieb. And he learned a lot about the case. He learned that the accusing party, Crystal Mangum, had given a number of different versions of what had happened on this night, and in fact had twice recanted and said that no rape occurred at all. She had alleged variously that she had been assaulted by 3 or 5 or 20 men. Mr. Nifong learned that the other exotic dancer who was present at the party called the entire story a crock. He learned that the 3 team captains of the Duke lacrosse team who lived in the house where this allegedly happened had voluntarily provided DNA samples for comparison purposes, had voluntarily given statements to the police, and had cooperated when the police executed a search warrant at the house. And he learned that those 3 team captains denied entirely Ms. Mangum's allegations. Mr. Nifong did not review all of the evidence that was available. He reviewed some of the evidence that was available. And he left that briefing and proceeded on a series of television and newspaper interviews, appeared on television, appeared on local television, appeared on national television, and said a number of things about this case. I won't go through all of them, but he made appearances on all of the local television shows. He made appearances on the MSNBC television program Rita Cosby Live, on Fox News, on CNN, on the O'Reilly Factor, on ESPN, and on Dan Abrams' show, just to name a few. And in these interviews, he said, the lacrosse players are not cooperating with the investigation. When asked about the 3 captains who had given these voluntary statements and provided DNA, he said, well, that would be considered cooperating, but if any of their statements are not truthful, that would not be cooperating. And when he was asked by the interviewer, well, are you aware of any statements made by any of those 3 men that are false? He said, well, they say a sexual assault didn't occur, and we don't think that's true. So therefore, they're not cooperating. He said that the Duke lacrosse players who had not voluntarily given statements were remaining silent on the advice of their counsel. And he said that may be good legal advice, but it's not good moral advice. He said if these Duke lacrosse players haven't done anything wrong, one wonders why they would need lawyers. He detailed Ms. Mangum's allegations on national television repeatedly as if they were established facts. He expressed his personal belief in the truth of Ms. Mangum's allegations. He went on national television and demonstrated the chokehold that the lacrosse player who allegedly assaulted her had allegedly put on her neck. Described how she struggled to breathe during the alleged attack. Stated that he was confident a sexual assault took place in that house. Said, quote, I'm convinced there was a rape. Yes, sir, close quote. He stated that he believed a crime had occurred. He stated that the guilty will stand trial. And there's no doubt a sexual assault took place. He talked about this being a crime that was motivated by racial hostility and hatred. He described racial slurs that allegedly were made during the alleged attack. He said that this was a crime that would not be tolerated in Durham. He called the perpetrators hooligans. He characterized the alleged crime as abhorrent, reprehensible, and absolutely unconscionable. He said this is a case that talks about what this community stands for. He threatened to bring aiding and abetting charges against any of the Duke lacrosse players who didn't come forward and give a statement. He said that he was personally appalled by the conduct that had been displayed here. He said this was the worst thing that had happened in Durham since he became the district attorney. He compared it to a quadruple homicide and to multiple cross burnings. And he said at a public forum, "I'm not going to let Durham's view in the mind of the world to be a bunch of lacrosse players from Duke raping a black girl from Durham." Now, either before he began giving these interviews or during the time he was giving these interviews, Mr. Nifong met with Investigator Himan and Sergeant Gottlieb and acknowledged to them that there were serious problems with this case, but he continued making the statements. On the night of the alleged attack, Ms. Mangum was taken to Duke University Hospital where swabs were taken from her body for evidence purposes. Some of her clothing was collected, and other evidence that had been collected was all sent to the SBI lab for testing, partially to determine if there was any DNA on any of this evidence that could be used for comparison purposes. On March the 30th, Mr. Nifong spoke with SBI representatives on the telephone and was told by them that their testing had revealed the presence of no DNA on any of those evidence items. Either that day or the next day, Mr. Nifong told reporters on film, on television, that he expected to receive the results of the SBI testing next week. He gave the reporters and therefore the public the impression that no one knew whether the SBI testing would show the presence of DNA or not. He then went on television and he began to talk about if there isn't any DNA, it doesn't matter, that doesn't mean a crime didn't occur, it just means nothing was left behind. Because a condom might have been used. He made several statements on national television that you would not expect to find DNA if a condom was used. At the time Mr. Nifong made these statements to the reporters, which were broadcast throughout the nation about condoms, Mr. Nifong knew that Ms. Mangum had told the nurse who interviewed and examined her on the night of the alleged attack that there was no condom used. Ms. Mangum had said that none of them used a condom and at least some of them ejaculated. Ms. Mangum had been shown 2 photo arrays. One of them had a picture of David Evans, who ultimately was indicted in this case. She was unable to pick out any of the alleged attackers. Mr. Nifong suggested that they take the 46 photographs that were obtained pursuant to the non-testimonial identification order and show those to Ms. Mangum and instruct her before she looked at the photographs that every photograph she would look at was of a person who the police had reason to believe were present at the party. In other words, you can't make a wrong ID here. And in fact, Ms. Mangum did identify Reed Seligman and Colin Finnerty with a 100% certainty as 2 of the men who had attacked her. And she identified David Evans with a 90% certainty as the other man who had attacked her. That identification array happened on April the 4th. After the SBI testing had shown the presence of no DNA, Mr. Nifong arranged to take all of those evidence items that had been tested by the SBI and send them to a private laboratory called DNA Security, Inc. The purpose was to see if perhaps more sensitive DNA testing might reveal the presence of DNA on any of these evidence items. So that evidence was in fact sent to DSI. And on April the 10th, Mr. Nifong had a meeting with the lab director of DSI. He and Sergeant Gottlieb and Investigator Himan drove to Burlington and sat down in a room with Dr. Meehan, Brian Meehan, who told them this: "Our testing has revealed the presence of DNA from several men. We don't know who those men are, but we do know that none of this DNA matches the profiles of any of the lacrosse players. So they are scientifically excluded as possible contributors of this DNA." On April the 17th, Mr. Nifong before April the 17th, Investigator Himan talked with Mr. Nifong, who wanted him to go forward and obtain indictments against Mr. Seligman and Mr. Finnerty. Investigator Himan expressed to Mr. Nifong his grave concerns about doing that, saying, "We don't even have any evidence he was at the party." Mr. Nifong instructed him to go forward nonetheless and obtain the indictments. Still concerned about this matter, Investigator Himan went to his superiors and expressed his concern, and those superiors expressed that concern to Mr. Nifong, that there's no evidence about that Mr. Seligman was even present at the time of this alleged attack. Mr. Nifong said, "Go ahead, get the indictments anyway." So on April the 17th, Colin Finnerty and Reed Seligman were indicted for first-degree rape, first-degree kidnapping, first-degree rape, first-degree sexual offense, and kidnapping. 4 days later, on April the 21st, Mr. Nifong again met with Mr. Meehan. Mr. Nifong, Investigator Himan, and Sergeant Gottlieb once again drove to Burlington and sat down with Brian Meehan. And at that meeting, Dr. Meehan once again explained that our testing has shown the presence of DNA from multiple men. We've done further testing since the last time we've met, and what we have determined is that some of the DNA that we found on the rape kit items belongs to Ms. Mangum's boyfriend. None of this DNA belongs to any of the lacrosse team members, except there's DNA on some false fingernails that were found in the trash can of Dave Evans' bathroom that had partial DNA profiles that were consistent with Mr. Evans and with another person who lived in that house. But on the rape kit items, there's DNA from several men, and none of them are lacrosse team members. One of the profiles matches the boyfriend. We've also got comparison samples from 2 other men with whom Ms. Mangum acknowledges having consensual sex in the approximate week leading up to this, and this DNA doesn't match any of them. This was told to Mr. Nifong in this meeting. Mr. Nifong said, "Well, I need you to prepare me a written report that contains the matches." So Dr. Meehan prepared a report. Now, preparing a report that contains the matches would only contain the fact that DNA from the rape kit was found on Ms. Mangum, matched Ms. Mangum's boyfriend, and that there was this DNA, these partial DNA profiles on the fingernails that were found in Mr. Evans' trash can that matched Mr. Evans and another member of the household. It would not reveal the presence of all this other DNA from men whose identities were unknown that had been found by the lab. Mr. Nifong indicated to Dr. Meehan that he needed this report for a court hearing that was coming up. On May the 12th, Sergeant Gottlieb, Investigator Himan, and Mr. Nifong once again drove to Burlington and sat down with Dr. Meehan. Dr. Meehan went through this again. He explained that there is this DNA from multiple unidentified males on the rape kit items taken from Ms. Mangum. He provided the report. It was exactly the report that Mr. Nifong had requested. It reflected the matches only. It didn't reveal the presence of all this DNA from the unidentified men. Three days later, Mr. Nifong sought and obtained an indictment against David Evans for first-degree rape, first-degree sexual offense, and kidnapping. These 3 men are defendants in a very serious criminal trial at this point. They serve a lot of discovery requests on the prosecutor. They're looking for a lot of things, but 2 of the things they're looking for are reports of the conversations that happened between Mr. Nifong and Dr. Meehan at these meetings at DSI Security, and all of the results of any DNA testing done by DSI, regardless of what its findings were, all the testing. Mr. Nifong responded to some of these discovery requests and not to others, but he did not ever provide any information about the conversations he had had with Dr. Meehan at these meetings, and he didn't ever provide complete results of all the tests that DSI had performed. So the defendants filed a number of motions to compel, and they were still seeking that same information. Memorializations of the conversations with Dr. Meehan and all of the DSI test results. There was a hearing on June the 22nd. Judge Ronald Stevens was presiding. At that hearing, Mr. Nifong represented to the court that no discoverable information had been discussed at his meetings with Dr. Meehan and that all communications with Dr. Meehan were privileged work product. Based upon that representation, not surprisingly, Judge Stevens did not enter an order specifically ordering Mr. Nifong to provide memorializations of his communications with Dr. Meehan, because, of course, he had said there weren't any other than the ones that are privileged. But the court did enter an order, and the court specifically ordered Mr. Nifong to provide to the defendants all witness statements, and all witness statements, any oral witness statements were to be in recorded or written form, and to provide the results of all testing and examinations that had been conducted in the case. So that order was entered by Judge Stevens on June the 22nd. Mr. Nifong did not comply. He did not ever provide any witness statement from Dr. Meehan or any memorialization of an oral statement from Dr. Meehan, and he didn't ever provide all of the test results. He had turned over the report that Dr. Meehan had prepared, but it only contained the 3 matches. It didn't contain the information about the unidentified DNA from the multiple male contributors. There was another hearing. The defendants filed more motions to compel. There was another hearing, September the 22nd, and this one was before Judge Smith, Osmond Smith. And in response to a direct question from Judge Smith, Mr. Nifong said that Meehan made no other statements to him in any of their meetings beyond the contents of DSI's written report, and that DSI's written report encompassed the results of all tests performed by DSI. At that September the 22nd hearing, the defense counsel said, I want to make it perfectly clear what we're asking for. We have received no evidence to indicate that any testing has revealed the presence of DNA from men other than the people who gave samples for comparison purposes. If there are men if there's DNA from men on any of these evidence items who are not members of the lacrosse team and who are not the 3 men with whom Ms. Mangum acknowledges having consensual sex during the week or so leading up to this event, we want to know about it. They said that in open court on the record. Mr. Nifong did not respond to that in any way. What they were saying is it's not in the report, but if it exists, we'd like to have it, and he did not respond in any way. At the end of that hearing, Judge Smith entered an order. He ordered Mr. Nifong by October the 20th to provide the complete file and underlying data of all DSI's testing. And the order expressly states, the court accepted Mr. Nifong's representations that Dr. Meehan said nothing during those meetings beyond what was encompassed in the final report of DNN Security dated May 12th. The court therefore held that no additional discoverable statements by Dr. Meehan existed for the state to produce. After the September the 22nd hearing, Mr. Nifong still did not turn over any evidence of the DNA from these multiple unidentified males. He was required to turn over the underlying data for DSI on October the 20th, but did not do so. And he was prompted by defense counsel and finally turned that information over on October the 27th. As soon as he received it, Bradley Bannon, one of the attorneys representing David Evans, took the 1,844 pages of underlying scientific data and started to study it. And he's not a DNA expert, but he went to school and he studied this paperwork and he tried to figure out what all this meant. But he didn't find the answer until after the general election. Mr. Nifong was elected DA. After the election, Mr. Bannon made it all the way through all this paper and figured it out. And he figured out that DSI had, in fact, found DNA from these multiple men who were not members of the lacrosse team and who were not any of the 3 men that Ms. Mangum admitted having sex with during the week leading up to this. So the defendants filed a motion. It was dated December the 13th. He detailed all of this. He said exculpatory evidence has not been turned over. When he received the motion, Mr. Nifong didn't pick up the phone and say, I have made a horrible mistake. I assumed the information was in DSI's report. I didn't read the report, but I assumed it was in there. I'm so sorry. Let me get it to you right now. He didn't call up defense counsel and do anything. He didn't file a written response. He just showed up at the hearing. And at the hearing, there was first a meeting in chambers with the judge. And again, Mr. Nifong didn't say, gosh, I'm really sorry. There was a mistake. I thought it was in there. He didn't say anything like that. All he said was that December the 13th motion was the first I've heard of it. No explanation of why it happened, no apology. Then there was a hearing in open court, and Mr. Bannon went through the entire process of the attempts to obtain discovery in this case and said exculpatory evidence was not turned over. Once again, Mr. Nifong did not say, I am so sorry. This was an oversight. It was a mistake. It's a very serious matter. I believe that the evidence was in the report. I've got to get it to you. He didn't say anything like that. What he did was he offered Dr. Meehan, said, Dr. Meehan, get up there and testify about what happened, and he did. Dr. Meehan testified that he discussed at the April 10th, April 21st, and May 12th meetings the results of all tests that were conducted by DSI to date, including the fact that there was the existence of DNA from multiple unidentified males on the rape kit items. Dr. Meehan also testified that he discussed and agreed with Mr. Nifong that we would only disclose or show on our report those reference specimens that matched evidence items. Dr. Meehan testified that DSI's report did not set forth the results of all tests and examinations, but was limited to only some results. Dr. Meehan testified that the limited report was the result of an intentional limitation arrived at between him and Mr. Nifong not to report on the results of all examinations and tests that DSI performed. Dr. Meehan testified that the decision not to provide all test and examination results was based on privacy concerns. And Dr. Meehan testified that he would have prepared a report setting forth the results of all DSI's tests if Mr. Nifong had asked him to do that. And he would have done that after May the 12th when the initial report was done, but he was never asked to do so. Now, at the time this hearing happened, the State Bar had already sent a letter of notice to Mr. Nifong about his extrajudicial statements, asking him to address the concerns about those. After this hearing on December the 15th, where Dr. Meehan testified the way that he did, the State Bar sent a second letter of notice to Mr. Nifong, asking him to address the issues that had been raised in that hearing. After he received the State Bar's letter of notice, he sent an investigator from the DA's office to go interview Ms. Mangum. And Ms. Mangum changed her story in a whole lot of ways in response during that interview. In fact, she said that Reed Seligman didn't do anything to her at all. After that interview, Mr. Nifong dismissed the rape charges but kept the sexual offense and kidnapping charges in place, even against Mr. Seligman, whom Ms. Mangum now said didn't do anything to her. In his response to the State Bar's letter of notice, Mr. Nifong gave a lot of conflicting, varied explanations of what had happened. He said he didn't realize that the information wasn't in DSI's report because he was so busy with his political campaign, that he had turned over the responsibility for providing discovery to assistants and legal assistants in his office. He said he didn't turn it over because he viewed the information about the DNA from multiple unidentified male contributors as non-inculpatory as opposed to specifically exculpatory. He said that it was not included because of privacy concerns. He gave a whole host of different explanations. After the letter of notice was served on Mr. Nifong, he recused himself from the criminal cases and the Attorney General's office took over the investigation. After reviewing all of the evidence, the Attorney General's office dismissed the charges and declared that Mr. Seligman, Mr. Finnerty, and Mr. Evans were innocent. The State Bar has charged Mr. Nifong with many rule violations, from making extrajudicial statements that had a reasonable likelihood of heightening condemnation of the accused and had a reasonable likelihood of prejudicing an adjudicative proceeding, to concealing exculpatory evidence, failing to provide information he was required to provide in discovery, making false representations to the court and the counsel. Any one of these, standing alone or taken together, would be conduct prejudicial to the administration of justice. The conduct, in fact, did not just have a reasonable likelihood of heightening public condemnation, but in fact it did heighten public condemnation of the three accused. It did prejudice the administration of justice, not just likely to, it in fact did. The State Bar's evidence will demonstrate that Mr. Nifong intentionally sought out the world's attention, went on television, talked about this case. When the world was focused squarely on North Carolina and its justice system, Mr. Nifong repeatedly and intentionally misled the media and therefore the public about a very serious case, caused racial unrest in Durham, intentionally concealed evidence to which he now admits the defendants were entitled, but which was extremely harmful to his theory of the criminal case, and made false representations to two judges in an effort to keep the defendants from discovering it. The harm done to these three young men and their families and to the justice system in North Carolina is devastating. The public perception is that justice can't be had in North Carolina unless you know how to play the shell game. If you can figure out how to play the shell game, you might get justice. The public perception is that the justice system in North Carolina has no integrity. This didn't have to happen. and the horrible consequences were entirely foreseeable. Thank you.
Ms. Jean, members of the Commission, let me state before I get going what this case is not about. This case is not about whether these 3 students from Duke University were guilty or not guilty. Their Attorney General's office has done a thorough investigation about that. Mr. Nifong asked for the Attorney General's office to come in and independently review this. They made a determination. They've come to conclusions that these boys are innocent, and we take no issue with that, and that's not going to be a contest here. I would also state this case is not about whether Mr. Nifong took a weak case and tried to take it to jury. I'd say as a prosecutor, while he has a number of duties, one of those duties is to the people of Durham, and that's to pursue a case he believes a crime has occurred, whether it is a strong case or not. If we brought all prosecutors in here who had cases that were dismissed along the way or dismissed as a result of insufficiency of evidence before a judge, or if a jury cut them loose at some point, or the grand jury found there was no probable cause, we would be flooded with cases left and right. It is not unethical. It is not unethical to pursue what someone may believe to be an unwinnable case. That is not the issue here today. The issue here today is to make a determination as to when Mr. Nifong was handling this case, whether he committed any intentional violations or negligently committed any violations of the rules of professional conduct, and we would contend he did not. The reason I wanted to preface that we're not advocating at all to disagree at all with what the Attorney General's conclusions were about the 3 young students are you still have to go back to March of 2006 and see what Mr. Nifong's mindset was at that point in terms of why he made the decisions he did. You must keep in mind, though while Mr. Nifong was a career assistant prosecutor for some 28 years prior to that, he had just become the DA, he had just become the appointed DA by Governor Easley less than a year prior to this event occurring, and he had actually been out of the regular rotation for trying cases for a number of years due to health problems he had suffered in the late 1990s, and he had sort of been operating on the district court level, and he was just now getting to the Superior Court level again as a result of his appointment to Superior Court DA. So while he was vastly experienced in the court system, he was extremely inexperienced in terms of running the office and sort of being in an administrative position. One must keep that in mind. But we heard from Ms. Jean some of the information that Mr. Nifong learned about what Ms. Mangum may have been saying. Other information that Mr. Nifong learned early in the case was that Ms. Mangum did make these accusations about what had occurred in the house on West Buchanan, that she contacted the police. The police went back over to the house where she said she'd been attacked, and everybody was gone from that house. Not just the people who had attended the party, everyone was gone from that house, thereby raising the suspicions of law enforcement, wondering why people would vacate that house, including the people who lived there. We're talking about in the middle of the night, if nothing had occurred at that time. They interviewed some of the people who were on the street who'd seen what had transpired in the street, and the witnesses on the street told the investigators that they heard racial slurs made by some of the Duke lacrosse students toward these 2 girls that were leaving in the car. Much is made about Mr. Nifong interjecting race. I would contend Mr. Nifong's comment on race was based upon that and some other comments that were made later on during the course of the investigation. Ms. Mangum was then taken to a SANE nurse, which is a sexual abuse nurse examiner, someone who is qualified to examine people who are accused of, who are alleged to have had sexual abuse committed against them. Her name was Tara Levison. Though she graduated very high in her class, she was relatively new in this field in terms of actually being out there. She examined Ms. Mangum that night, and she determined that Ms. Mangum was acting consistently with someone who had been sexually abused that evening, that she appeared to be in pain, that the way she was reacting was consistent with someone who had been sexually assaulted, that she did not appear impaired, and as far as she would be allowed to testify, she will say, and you will hear from her, that she appeared as somebody who was sexually abused that night. So now we have law enforcement with someone saying they were attacked. We have them going back to the house, trying to find out what happened, where everyone is gone. We've got people saying there were racial slurs made toward the individuals, all consistent with what Ms. Mangum was saying. They went, within the next day or so, back to the house to execute a search warrant. In executing the search warrant, you'll hear Detective Himan, Investigator Himan testify, they knocked on the door several times for 45 seconds to a minute. Nobody came to the door. When they let themselves in, and when they came in, they found the 3 individuals who were living there who did go down and make voluntary statements. But in their voluntary statements, they made statements, though they denied any sexual misconduct toward Ms. Mangum, they made some statements that corroborated what Ms. Mangum said. In addition to her being there to do topless dancing, she had mentioned to the investigators that she was threatened with a broom to be used untowardly toward her, and they were told by the people living in that house that she was threatened with a broom. She told them about racial comments that were made toward her, and they told her. They told the investigators about racial comments made toward her. So now you have an investigator looking at this. You have her statement. You've got the sayings. You've got the comments corroborative about the broom and about racial comments from people in the house and about witnesses on the street. In addition, during this period of time, they find an email. They find an email from one of the lacrosse players talking about skinning the strippers. Skinning the strippers. Some may see that as some sort of innocent comment, not Mr. Nifong. So this is the information that's being brought to Mr. Nifong. And I would contend to you, Investigator Himan will tell you, as he said under oath, I would contend what he said under oath in deposition, that when he talked to Mr. Nifong and they asked about Ms. Mangum, he said she sounded like she was telling the truth. During this period of time as well, initially there were the 3 individuals who came forth and made the statements, and a number of other individuals were supposed to meet with Investigator Himan and Sergeant Gottlieb. During that period of time, they got in touch with lawyers, and those lawyers advised them, probably as I would do, not to make any statements. There's nothing wrong with that. And there's certainly nothing that you could ever use in the courtroom. However, what we're talking about is the mindset of Mr. Nifong in terms of what is going on. He's looking at this case, and he's trying to make a determination about if these people initially came forward and now everyone is being quiet, why is that? And then he starts making the statements that he does. But when he starts making those statements that he's making, and I believe you will hear him testify that he regrets making those statements, but in those statements that he made, he was not making them with the intent to substantially prejudice the jury. At that point, there had been nobody charged. They were still looking for suspects. And he felt, as the duly elected, or as the DA of Durham County, he needed to solve this crime. He wanted to get out there to the public how serious this crime, that he believed a rape had occurred, that there are 3 people out there who, at least 3 people out there who were involved, and he wanted to solve this crime. And his statements were a way of getting out there saying, people need to come in and tell me, because we need to know, we need to put a bed to that. That being said, and again, some of the statements clearly were outlandish, we're talking about a very brief period of time. We're not talking about someone who talked from March until January 2007 when he got out of the case. I would contend 98% of the statements you're going to have before you were made between March 8th and April 4th. And then he stopped talking. He realized, again, I'll let him testify, but I believe he realized, A, it would be improper to go on. And secondly, too, at this point, they were starting to narrow down who the people were, and he was not going to make comments once an individual was charged. And I contend almost all statements are made prior to anybody being charged, and they're not being made in reference to any one individual at the time they're being made. You've heard some comment in opening statement about the photo array that was shown to Ms. Mangum and whether it was suggestive or not, or the improper nature of it. Rather than hear our conclusions or our arguments about the suggestiveness or lack thereof of the photo array, you'll have the opportunity to see that. Mr. Nifong, because this was a relatively new procedure, and he will liken it to the yearbook identification when he knows somebody was wearing a certain high school sweatshirt, and he'll show a yearbook to the individual who's making the accusations from people who were at that high school to see if they can help identify him. He knew this was a new photo array, was not positive as to how it would play in court. See, he taped it. He taped it, so we don't have to worry about whether there was some sort of suggestive nature of it. You'll be able to see it. You'll be able to make your own determination, not listening to either side about how you should interpret it. You can make your own determination as to about how suggestive it was and the purpose of it. We would contend the purpose of it was not to sort of circumvent the typical photographic lineup, but to try and locate witnesses in terms of people the police could try and talk to make a determination as to what happened that night and perhaps solve the crime that they were very thoroughly investigating. You heard at that point she did make several photo IDs. You heard Ms. Sheen comment about Mr. Himan expressing grave concern about indicting Reed Seligman. What I will contend you'll hear, and again this is just opening statement, but you will hear Mr. Himan stating to Mr. Nifong about, I'm not so sure whether we should indict Mr. Seligman because we can't prove he was there at the party. I would contend that was the reason why he was expressing those concerns, at which point Mr. Nifong said to Investigator Himan, if you believe her on Finnerty, then you have to believe her on Seligman. Whereas if you believe what she says on Mr. Finnerty, then you have to believe her on Seligman, at which point the investigators went forward. Mr. Nifong did not generate a warrant on his own. He had the investigators go in to present their case to a grand jury. There'll be no evidence of any kind that they were instructed how to present the case to the grand jury, whether just to include this evidence and not this evidence, but present the case to the grand jury and let a grand jury make a determination as to probable cause whether these crimes occurred. After a presentation, and I don't believe the State Bar is going to have any evidence at all to say it was Investigator Himan was doing anything improper or was instructed to do anything improper, after a proper presentation before the grand jury, they returned the indictments of probable cause. The grand jury determined there was probable cause to go forward as to Mr. Seligman and Mr. Finnerty at that time, and subsequently after Mr. Nifong received the DNA report and information from Dr. Meehan saying that there was DNA on the fingernail that was consistent with Mr. Evans' DNA, which corroborated what Mr. Nifong believed to be Ms. Mangum's statement that she had scratched one of the players and that she had DNA under her fingernail. Then he went ahead and indicted Mr. Evans. Again, did not generate a warrant on his own, but presented it before the grand jury for probable cause. The jury came back with probable cause. So I would contend there is no evidence at all to say anything that was presented to the grand jury was improper or not presented to them properly. And you've heard nothing about that either in the amended complaint or in the opening statement. As to the DNA, Dr. Meehan, which I would contend, if you look at the sort of contested issues, is sort of the real crux of this case, sort of the what did Mr. Nifong know and when did he know it? There's not a whole lot of contention about what went on in those meetings on April 10th, April 21st, and May 12th. In fact, I think you'll hear from Investigator Himan, and if Sergeant Gottlieb testifies, and Dr. Meehan and Mike Nifong pretty much the same. That there was DNA there was no DNA consistent from the rape test kit consistent with any of the Duke lacrosse players. The only DNA at all they found at any time was under the fingernail that was found in the bathroom that was consistent with Dave Evans. Mr. Nifong had never used Dr. Meehan before. And the reason he was going to Dr. Meehan was, again, that Dr. Meehan could do a certain sort of DNA testing, YSTR, I believe it's called, where you're just looking for DNA for males. And that's why you use this. And it is a very sensitive testing, much more sensitive than what the SBI can use, because a lot of times they can draw DNA from a cell or less. They meet with Dr. Meehan. Dr. Meehan gives them the information about the various aspects of what he has found. But what does not occur, and what you will not hear from one witness in this room, is that Mr. Nifong ever asked Dr. Meehan to exclude anything from that report. He said so on December 15th, and I contend he has said so under oath in his deposition, and I contend he will testify that today. He was never asked to exclude. Mr. Nifong never told Dr. Meehan how to write his report. Dr. Meehan, when he was giving the results to Mr. Nifong on his own said, I have privacy concerns. I have read quite a bit about this in the paper, and I'm concerned. I know that as soon as the SBI test results came out, everything about the SBI results were in the paper, and I'm concerned that anything I may put in this report, again, will be out there. I've got the DNA profiles of 46 players, and I don't feel it would be appropriate to place that out there. And he expressed his concerns on a number of occasions, and at some point Mr. Nifong said, well, I know that, but at a minimum, I at least need the matches in that report. Not, let's leave any other evidence out. Let's leave the DNA. But at a minimum, you write the report you want, but what I need right now, at a minimum, is the matches. And I believe you'll hear that from, again, all of the witnesses who are presented. Not in any attempts to exclude anything and to keep things away from the defense, but as a way of protecting the privacy of the DNA profiles. What you will also hear from Dr. Meehan, is that on page 5 of his report, he talks about I have other non-probative evidence that I'm retaining in my office for other people who would like to see it. What I contend to you he's going to say on the witness stand is when he was talking about the non-probative evidence was when he was referring to the DNA that was found in the underwear and the one piece of DNA that was actually found on Ms. Mangum that was not identified. Not that Mr. Nifong asked him to write the report saying, please put that as non-probative, and I believe Dr. Meehan will state that perhaps was a poor choice of words on Dr. Meehan's part, but Dr. Meehan said according to industry standards that was sufficient to indicate he had other evidence out there that had not been identified for people looking in the report, and that they should know that. So this is, again, what I believe the evidence will be and presented, but there is no evidence, none, of any sort of agreement with Mr. Nifong and anybody to exclude evidence. And I would contend even the State Bar has become aware of that, because if you look at Issue 10 on the issues that are contested, where if this was corresponding with what the complaint they had filed said, in the complaint they filed about an agreement between Dr. Meehan and Mr. Nifong, Issue 10 no longer talks about an agreement between Mr. Nifong and Dr. Meehan. It said the defendant, by instructing Dr. Meehan to prepare a report containing positive matches, is where the language goes. It no longer goes to whether there was an agreement. It goes whether instructing him to do a report just to have positive matches, and I would contend to you He even said less than that. He just said, at a minimum, this is what I mean. And both Dr. Meehan and Mr. Nifong will testify that this was an interim report, that discovery was an ongoing process, and this was not intended to be a final trial report. When Mr. Nifong got the report, he turned it over. At that point, something else you need to know about Mr. Nifong is that Mr. Nifong, before all the rules had changed about discovery, he had believed, I believe the testimony will show, that he had believed in open file discovery, that instead of sort of looking through the reports and seeing what should he turn over and what should he not turn over, he'd get a report, and without really reading it, for better or for worse, he'd turn it over to the defense. He'd always done it in the past because he wasn't trying to exclude anything he never had before. So he would not go through his reports to determine what should he give the defense and what he should not. He just always gave everything over, which he did in this case. Perhaps he should have been a little more aware at that point that he had not turned over, that the report he'd gotten did not include the DNA that was located in the underwear and the one other piece of DNA on her. But he did not look, as he did not look at any of the other discovery, he pretty much just turned it over. One of the reasons, and I believe you'll hear this as well, is Dr. Meehan can tell very little about the DNA that we've heard about that's located, the up to 4 males of DNA in the underwear and the one on her, other than at some point there was some male contact. It's extremely weak profile. That's why he listed it as non-probative evidence. It is an extremely weak profile. He said the 3 ways the DNA could have gotten there, or I'll contend to you, he'll say the 3 ways the DNA could have gotten there, was some minimal contact and some period of time. Doesn't know when. 2, whether it's very weak because of degradation, in terms of that it had been there for some period of time and had just become weak over a long period of time. Or number 3, and he said it's not likely, but number 3, some mishandling of the evidence. And because he could draw no conclusions from that DNA other than that it excluded the 3 lacrosse players who were charged, which we already knew they were excluded, because all the DNA showed they were excluded from all the rape test kit, that he could draw no conclusions from that. Mr. Nifong, in hearing that, perhaps should have thought more of that evidence, but did not, because he didn't really see how, he did not understand. At this point, I believe he does have a better understanding of the fact that it's potentially exculpatory. I don't think I believe he will testify that at that point that was not first and foremost on his mind. So in making the statements that he did to the judge during the period of time, at that point he believed he had turned over everything to the defense. And he continued to comply with discovery. In September, there was an order entered in June, shortly after he turned the DNA over, where the judge specifically said, at some point you're going to have to turn over all the underlying data that Dr. Meehan has. It says you're going to have to turn over the underlying when the court orders you to do so, which the court ordered to do in September, and he turned it over in October. And at that point, he turned over everything he had obtained from Dr. Meehan, including the underlying, including the DNA that we now know about. The way the defense got the potentially exculpatory evidence about the DNA in the underwear was from Mr. Nifong. He turned it over. You'll hear nothing about him saying, Dr. Meehan, well, perhaps we should move for some protective order on this, or we should exclude that. He just turned it over. Ms. Jean talked about the fact that he turned it over in a bulk group to the defense and Mr. Bannon through his experience, and Mr. Bannon is a very experienced lawyer and did an excellent job in this case. But Mr. Bannon, in September 22nd, when he was asking for all the material, says he wants to get that material to their experts. So it was their understanding at the point when they're turning over their DNA evidence that the DNA evidence that the state had was now being turned over to the defense experts to look at. I do not know at this point who actually, I'm sure we'll find out how this actually came to light, but there was references made that they had experts online and ready to look at that, at which point it was all turned over. I ask you to examine the December 15th hearing of Dr. Meehan, because I believe he made a number of statements. Part of the problem with the December 15th hearing with Dr. Meehan was that he wasn't prepped. When Mr. Nifong got the motion on December 13th that suggested that perhaps he was hiding evidence and that was not in there, because in the motion itself it specifically talks about how any defense lawyer or prosecutor should know this is potentially exculpatory information. He doesn't call Meehan and say we've got to cover this somehow. He doesn't call Meehan saying you've got to be prepared to testify for this. He calls Dr. Meehan the day before and essentially says there may be some bad publicity for your office, come in and testify, and doesn't really fill him in on anything else, because Mr. Nifong believed since there was some question about that, he was just going to let Dr. Meehan get up there and state what went on, so there'd be no question and there'd be no issue about whether he was actually trying to hide something or not. But I believe even in the December 15th hearing, with Dr. Meehan being all over the place, he specifically said Mike Nifong never asked him to exclude anything from that report. And in the December 15th hearing, he does say at that point that the other information from the underwear and from on Ms. Mangum was spelled out as non-probative evidence. So he was explaining that as early in that, and I believe one of the last statements you'll see Mr. Nifong actually make in this case, he makes to the New York Times shortly after this hearing, where he says, yes, this was potentially exculpatory evidence, and they were entitled to it, not trying to come up with any justification for hiding it. And maybe he didn't come in and say, gee, I'm sorry, I should have turned that over or something. I don't know that that's a specific ethical violation. He did not do that. And I believe, obviously, the State Bar will have the opportunity to ask Mr. Nifong. I don't believe that would be consistent with anything I've seen from Mr. Nifong and his behavior about how he acts on all sorts of cases. He then asks the attorney, he doesn't try, once he realizes there's a problem and the State Bar files a complaint against him, he doesn't try and dismiss the case and close the file and keep it away from investigation. He turns it over to the AGs, asking for a complete independent investigation, for them to look through everything, for them to make a determination, and says early on, whatever determination they make, I'll respect and I'll stand by, which he has. So I contend, as to the memorializations, I would contend that the law was in a state of flux at that point, that he was the position he was arguing in all of his motions or in all of his hearings you have before you will be positions that were consistent with what the Attorney General's office was telling the DAs to argue, that they don't have to memorialize all these various things, as they had not done so in the past. The case law came down after he turned over the case to the AG, State versus Shannon, which says they should memorialize, which is a 2-to-1 opinion, which has now been appealed. What I guess was heard right here is now being appealed over to the Supreme Court. So I contend to you the law was in a state of flux at that point, and his comments about memorialization was just consistent with the Attorney General's perspective at that point, and he should not be held to be accountable. So in hindsight, I would contend you look at the man, you look at his career, you look at what he had on his plate when he was handling this case. They talk about political gain. I contend to you there's nothing political about Mike Nifong. This was his first run for office. He did not seek this office. Mr. Nifong, I contend the evidence will show, is someone who sees things, something he believes to be right, and that's what he pursues. I contend that this case has been complicated a great deal, both initially and obviously even up to this point by the intense media interest. Mr. Nifong didn't create the media interest in the Duke case. Mr. Nifong didn't ask for the media to come down here and start asking about the Duke case. And Mr. Nifong quit talking about the case in early April, which obviously has not dissuaded the media interest in this case, I think as evidenced by this courtroom today. The media operates as they see fit. Just because they're interested in the case doesn't mean Mr. Nifong should be held any differently than anyone else in his position. And I know that this panel will not treat him in that fashion. So I contend to you, when you hear all the evidence, you realize Mr. Nifong at no time committed any intentional violations of the State Bar. and I want to thank you for your time beforehand, and thank you for the job that you do in serving the lawyers in North Carolina.
At some point during the investigation, initial investigations, were you informed about the involvement of the defendant here, Mr. Nifong?
Excuse me?
At some point during the initial investigations, did you become aware or become informed about the involvement of Mr. Nifong?
Yes.
And what did you find out at that point?
I believe he wanted to be updated with the case, and I believe Sergeant Dowling told me that he'd been told that anything that we're going to do, make sure that we talk with Mr. Nifong.
Okay. I know you're trying, but the panel really can't hear you, so can you try to repeat that answer for me and just project a little louder? Right. If you would just...
Sergeant Gottlieb had advised me that we were supposed to, if we were going to do anything, that Mr. Nifong wanted to know what we were going to do and to go through of what actions we were going to do.
Can I approach for a minute with one of the defense counsel, possibly just 30 seconds?
Yes.
Investigator Himan, we were talking about, I asked you whether at some point during the investigation you became aware that whether or not Mr. Nifong was going to have any involvement in this. And could you repeat for the panel what you became aware of? And again, just try to keep your voice up as much as you can.
I was advised that anything that we did, we were going to go through Nifong, any search warrants or anything that was going to be conducted, he wanted to be aware of, and we were going to go through him with those requests.
Okay. And at some point after that, did you meet with Mr. Nifong to brief him on the case?
Yes.
And who initiated the initial briefing?
I believe Mr. Nifong did.
Do you know when that meeting was?
No, I do not.
If Mr. Nifong has indicated in one of the documents here that's been admitted into evidence that occurred on the morning of March 27th, does that sound consistent with your recollection?
It could have been that day. I don't have it documented anywhere, so I don't know.
Okay, I'm sorry. Can you say it again?
It wasn't documented. I don't know what's the actual date I actually met with him at.
Okay. And who was present at that initial briefing?
Sergeant Gottlieb and myself and Mr. Nifong.
And where did it occur?
The DA's office.
Generally, what was the purpose of that first meeting with Mr. Nifong?
I believe he wanted to be updated of where we were at in our investigation.
And generally, can you tell me what was discussed?
He basically discussed he asked us what our initial findings were, when we talked to Crystal, what we got from the search warrant, and the players' interviews, and basically we updated him on the case.
Okay. Did you bring him up to speed? Did you bring him up to speed on what types of investigation activities you had done to that point when you sat down with him at that initial briefing?
Yes.
Did you discuss, I want to ask you just sort of a series of questions about what specifically, whether or not you discussed certain things. Did you, during that initial briefing, discuss the interviews you had had with Ms. Mangum?
Yes.
And did you discuss the execution of the search warrant?
Yes.
Did you discuss whether or not any of the residents had given statements?
Yes.
And what did you tell Mr. Nifong about whether or not any statements had been given?
Statements have been given by the three players that we first interviewed, Dave Evans, Matt Zash, and Dan Flannery.
Okay. Can you repeat that last answer? I'm not sure the panel heard that.
Matt Zash, David Evans, and Dan Flannery we got statements from.
And did you discuss with Mr. Nifong whether or not those 3 players had provided suspect kit items or evidence?
Yes, we would have talked about that, what they gave and what had happened.
And during that initial briefing, did you discuss with Mr. Nifong your interviews with Ms. Pidnam that we've just been discussing here?
Yes.
Did you talk with Mr. Nifong about the photographic arrays that had been done with Ms. Pidman during that initial briefing?
Yes, I believe he brought them up to us, I believe.
And did you tell Mr. Nifong whether Ms. Mangum had been able to identify any of the alleged attackers in those prior photo arrays?
Yeah. Yes.
Okay. And what did you tell him?
That she didn't identify anyone.
That she had not been able to identify anyone?
Correct.
And did you discuss the report from Duke from the sexual assault nurse during that initial briefing?
Yes, we would have had that by then.
At that initial briefing, was there any discussions about potential inconsistencies in the Ms. Mangum, the accuser's stories?
I believe he brought up some inconsistencies from, that's on my recollection. That's where I remember where the conversation started at.
Okay, I'm going to make sure. Can you say it again? Who was it that brought up any inconsistencies in Ms. Mangum's statement during that meeting?
I believe he did.
He being Mr. Nifong?
Yes.
And what do you recall Mr. Nifong discussing in that initial briefing about discrepancies or inconsistencies in Ms. Mangum's statements?
He made the comment, something to that effect. There was no toxicology report.
Can I stop you because you've got to speak loud enough for the panel to hear? What do you recall Mr. Nifong saying about the inconsistencies or the discrepancies?
I don't know about the actual discrepancies. The statement came out.
Mr. Nifong said that to you.
Yes.
Again.
Let go ahead and answer.
I'm sorry. I'm just trying to get.
Let me just say something. Mr. Himan, if you'll just almost feel like you're shouting, it would help us. Because we are having a very difficult time hearing you, and I apologize, but your normal speaking voice is difficult for us. Just yell it out.
Mr. Chairman, perhaps if you faced you all would answer.
I don't think that makes a difference.
If you can again repeat the comment that Mr. Nifong made as audibly as you can so people can hear, and then everything else from there on out, if you really can do that, please.
He said with the effect, we're and he said basically there was no toxicology report done. There's discrepancies done in a report, and basically went on with the investigation, or what had gone wrong with the investigation. During that time, he asked us what our experiences were. He asked basically Gottlieb what his experiences were, how many rapes he had done, and asked me how many investigations I had done. That was to the statement of that.
Okay. So during this initial briefing, when you were discussing what the investigative activities that had been done before, Mr. Nifong said to you something to the effect, we're fucked.
Basically on how this was going to go to court, how it was going to be in trial, I believe, and that it was going to be a hard case to prove.
Did Mr. Nifong during that initial briefing bring up any inconsistencies or discrepancies concerning Ms. Mangum's use of alcohol or whether she was drunk on that evening?
I believe, that was also brought up also.
He did?
I believe either we pointed it out or he would have asked it.
Did Mr. Nifong indicate how he was aware of any of these discrepancies or inconsistencies in that initial briefing?
I don't believe he told me how he was aware of it. I just assumed he was aware of it, or figured to me he was aware of these issues.
Well, you said you assumed, but did he actually bring those up initially?
Yes.
At the time of this briefing with Mr. Nifong, during your initial investigative activity, was there anybody else present at the party who had made a statement which corroborated Ms. Mangum's allegations that she had been raped or sexually assaulted?
No.
And from the context of the conversation, was it your understanding of Mr. Nifong's statement to the effect, related to the problems or inconsistencies that you have been discussing in the investigation?
I believe his statement was the problems in the investigation, yes, and the inconsistencies.
After this initial briefing with Mr. Nifong, did you continue to meet or discuss with him about the status of the investigation as it went along?
Yes.
And approximately how frequently did you meet with Mr. Nifong during the initial stages of the investigation?
I would say daily or every 2 days or 3 days.
Okay. Every couple days at least?
Every couple days.
And was Mr. Nifong kept fully apprised and informed about the developments and the status of the investigation?
Yes.
During those subsequent meetings or briefings, did Mr. Nifong make any other comments about the strength of the case or the investigation?
The strength, I believe he always said it was going to be a circumstantial case, and that's how I believe most rape cases are.
Okay, I'm sorry. Can you say that again?
He said it was going to be a circumstantial case. That's he said, she said, and that's how most rape cases are.
Did he say anything in those meetings about whether or not it would be difficult to prove the allegations here?
Yes, that was said I believe in the first initial meeting that we had with Mr. Nifong.
And what did he say about whether it would be difficult or not to prove the allegations?
He said it was going to be hard to prove in court to prove these allegations happened.